Good morning, everyone. My name is Heather Exner-Pro. I'm the Director of Natural Resources, Energy, and the Environment at the Macdonald-Laurier Institute. Thanks for joining us today. I'm coming to you from Fort McMurray, my first time here, so I just want to acknowledge that I'm on Treaty 8, the homeland of the Cree, the Dene, and the Métis. So why are we here together today? On October 13th, the Supreme Court of Canada, in a 5-2 decision, held that the majority of the Impact Assessment Act was outside Parliament's lawmaking authority and thus unconstitutional. The court iterated that the federal government must be careful to not overreach into areas of provincial jurisdiction. In the aftermath of that decision, there's as much confusion as ever as to what it means and how much of the IAA can stand. So to help us understand the decision, I'm very pleased that we have been able to gather 4 of the country's foremost legal experts on the topic to share their perspectives and their opinions. I will briefly introduce them before we get into the meat of the webinar. First, we have Martin Ignasiuk, KC, who is a partner at Bennett Jones LLP. In his capacity as a regulatory lawyer, Martin has negotiated numerous benefit agreements, has developed and executed strategies for obtaining regulatory approvals for large-scale industrial projects, including mines, oil and gas, pipelines, and electric generation facilities. And he's appeared before all levels of court, including the Federal Court of Appeal, Supreme Court of Canada, as well as numerous regulators. On top of Martin, we will have Martin Killoran, KC, who's the national co-chair for Osler, Hoskin, and Harcourt LLP. Maureen is the firm's national co-chair and a member of the firm's partnership board. Maureen practices out of both their Vancouver and Calgary offices, and a significant portion of her practice involves litigation related to major resource and transportation projects and undertakings. She routinely appears on matters of judicial review, regulatory appeal, and environmental, administrative, constitutional, charter, and Indigenous claims in federal and provincial courts across the country. Also joining us is Jesse McCormick, who is the Senior Vice President of Innovation, Research, and Legal Affairs for the First Nations Major Projects Coalition, and my co-author on a few papers. Jesse McCormick leads cross-cutting innovation and services for the FNMPC and contributes to policy initiatives, legal proceedings, and stakeholder engagement focused on improving the participation and influence of First Nations in major project development in Canada. He has affiliations with the Liberal Party of Canada and the Banff Forum, and is the co-chair of the Indigenous Peoples Commission of the Liberal Party and also chair of the Indigenous Relations Council of the Canadian Nuclear Association. And last but certainly not least is Martin Olszynski, associate professor at the Faculty of Law at the University of Calgary. Before he was a professor from 2007 to 2013, he was counsel with the Federal Department of Justice and practiced law in the Legal Services Unit at Fisheries and Oceans Canada. He also spent time on secondment to the Legislative and Regulatory Affairs Division at Environment Canada. I found this interesting, Martin. He not only holds a BSc in biology and an LLB and an LLM, but he is currently pursuing a PhD in resource management at the University of British Columbia. 4 extremely intelligent and experienced people. So thanks so much for having us. I'm going to turn right over to them and ask each of them to start with about 3 or 4 minutes to kind of give their perspectives on the decision, what surprised them, what they think was most impactful, and how they see it going from there. So Martin Ignasiuk, I'll start with you.
Thanks, Heather. First, thank you to you and the Macdonald-Laurier Institute for your invitation to participate today in this webinar. Heather, you and the MLI do a lot of great public policy work, and it's an honor to be involved in that work today. I'll start by saying that the Supreme Court of Canada's decision in the reference case is obviously one of the most important cases with respect to the boundaries of federal environmental assessment. That said, I think it should be recognized that the court's decision is not as broad in scope as some have suggested. While it offers some hints of where the court might go in future cases, potentially involving clean electricity regulations or other federal initiatives, the case is really focused on federal assessment, and in particular when and to what extent the federal government can enforce prohibitions on carrying out projects pending the carrying out of a federal environmental assessment. So as everyone knows, the court determined that the designated project scheme established under the IAA is constitutionally flawed. The court stated that, and I quote, "Parliament has plainly overstepped its constitutional competence in enacting the designated project scheme," end of quote. So the immediate and practical consequences of this finding are significant, because as part of this, the court determined that the IAA's prohibition, preventing certain projects from proceeding on the basis that they may cause federal effects, including on fish and Indigenous peoples, is unconstitutionally broad because it captures, and I quote, privately or provincially funded projects that are on provincial lands and that do not otherwise require the exercise of a federal power, duty, or authority. Therefore, on the ground today, there are projects that are finally proceeding that prior to the Supreme Court of Canada's decision in October could not proceed as a result of the IAA's prohibition. And I'm referring to those projects, including mines and other facilities that were subject to the IAA, even though the proponent did not require any other federal approvals under the Fisheries Act or other federal legislation. So the court's decision has had some real and immediate implications for many of those projects that are able to proceed today and couldn't previously. In addition to this immediate impact of the court's decision, it obviously should have significant implications for any future environmental assessment regime. The court confirmed that the federal public interest decision must focus on the acceptability of the adverse federal effects only and not veer towards regulating project qua project or evaluating the wisdom of proceeding with a project as a whole. So the decision makes it clear that Canada can't simply regulate mines, power plants, highways, or other major infrastructure because they are large-scale industrial projects with environmental, social, or health effects. Canada must instead remain laser-focused on regulating federal matters. In my view, the court has made it clear that federal environmental assessment should apply in cases where Canada is exercising a federal regulatory power. And for most natural resource projects in Canada that are not on federal land, that means projects that require approvals under the Fisheries Act or Species at Risk Act. So in conclusion, from my perspective, I'll say that the good news is in addition to respecting the division of powers in Canada's Constitution, the court's decision in the Impact Assessment Act reference also provides guidance for federal assessment that, if respected, will allow for the development of good federal policy that will respect the role of provinces, reduce duplication, shorten regulatory timelines, provide proponents with greater predictability and certainty, and result in more focused assessments that ensure projects are carried out in an environmentally responsible way. So Heather, thank you very much.
Thanks, Martin. You make a good point that I just want to highlight for the audience too, is this affects mining more than any other industry right now based on the number of projects. So people have an idea that it's the No More Pipelines bill, and this is a bill about pipelines, but obviously it's about all major projects. So mining industry looking very closely at the implications. Maureen, we'll turn it over to you.
Sure. I'll try not to repeat too much. Martin, Ignatiuk, and I usually agree on everything. So I'll try to edit my comments to the extent they're duplicative. But in my view, the Supreme Court of Canada's opinion on this matter is among the most important rulings on environmental regulation in Canada over the past 3 decades. They found that one of the federal government's signature legislative initiatives, the Impact Assessment Act, was far outside federal Parliament's constitutional authority to assess and make decisions regarding major resource and infrastructure projects. So this is a really big deal for Canadian federalism, and in particular for the provinces. And in my view, the decision restores a balance to provincial and federal powers to determine which major resource projects in Canada can proceed and on what basis. So for projects that cross provincial or international borders, such as the Trans Mountain Pipeline, the federal government holds most of the power. And for those of you who've been paying attention, you'll remember the federal government appeared before the Supreme Court of Canada on the Trans Mountain or the pipeline reference a few years back and made exactly the opposite arguments there successfully. I was in both cases, both Trans Mountain and C69, and it was quite interesting to see the government take one position when it came to their federal pipeline and a very different position when it came to provincial projects. But I digress. Anyway, so for projects that are located entirely within a province, and as Martin says, mining, great example, oil sands, the Supreme Court decision restricts the federal government's ability to say no to these projects or to hold them up in a federal process without defined timelines and this vague assessment parameters such as sustainability that we saw in the IAA. So given the increasing number of conflicts between the development priorities of one level of government in Canada with the environmental priorities of another, which is probably only going to increase as we progress with energy transition, this decision is a really big deal, and it's a really big win for supporters of resource development. Martin talked to you a little bit about, the court, the majority 5-2 opined that the vast majority of the act was unconstitutional because it went far beyond the scope of federal powers. And when we talk about the vast majority of the act, and this will become relevant, Heather, when we talk about a few other things in a minute, only 10 of 188 sections wasn't declared unconstitutional. So, you'll hear federal ministers talking about tweaking the act to make it constitutional. It's a pretty big tweak. So the only sections that actually withstood the challenge were really narrow sections that consider projects on federal land and that are federally financed. The court was really concerned by the fact that the act regulated projects in their entirety rather than limiting the assessment to areas of federal authority. And they said it defined the effects that it sought to regulate too broadly. They also explained that the act allowed the federal government to make decisions as to whether projects may proceed that were based on factors that were well beyond the federal heads of constitutional power. And fisheries is one of those, and that's one we saw in the old legislation as being a head of power that the federal government relied on. But instead, they were looking for decisions based on concepts like sustainability. Sex and gender was another element, or the federal government's view of public interest. And the court was really concerned that the federal government was looking to make decisions not based on areas of federal jurisdiction like fisheries, but instead based on a more holistic view as to whether a project should proceed. And in doing that, they're broadly stepping into provincial jurisdiction. So the court noted that while the act purported to focus on defined effects within federal jurisdiction, the list of what was included as those effects within federal jurisdiction went far beyond Parliament's powers in the Constitution. And it included an overbroad approach to GHG emissions. I'm sure we'll talk a little bit about that. But anyway, what does it mean? I think it fundamentally alters the scope of federal assessments and decision-making over the vast majority of major projects, such as critical minerals, mines, upstream oil production, oil sands, pipelines located wholly within a province. But Parliament needs to go back to the drawing board. They need to consider significant amendments. They need to look at that decision in good faith. And to the extent that there is new legislation, it ought to be guided by the jurisdiction and the opinion of the Supreme Court of Canada. And hopefully this decision puts a halt to this trend of increasing federal attempts to regulate projects that are primarily regulated by provinces under the Constitution. The message is pretty clear. It tells the government to stay in its own lane, the federal government. And what's also really important, and Martin said this as well, it doesn't completely eliminate their ability to, or their role in the assessment of projects and located entirely within a province. To the contrary, the decision confirmed that the federal government does have a role. It's just limited to an assessment of effects of the project on areas of federal jurisdiction, such as fisheries, not an assessment of the project as a whole. So it's an effects-based jurisdiction, not a project-based jurisdiction. Ultimately, as well, there was a couple of interesting lines that Chief Justice said at one point, and I'm paraphrasing, stop bringing your bun fights to the Supreme Court of Canada. And he encouraged the provinces and the feds to cooperate and hopefully come up with some solutions themselves. It remains to be seen whether that can be done, but
I'll shake my magic 8 ball. So far, no signs pointing to that. So you mentioned, Maureen, that you and Martin Ignazic tend to agree on everything, but I wanted to keep this webinar spicy and also, kind of address the questions that are being raised in good faith with different perspectives. So I'm very delighted that Jesse and Martin Olszynski have joined us. Jesse, I'll turn it over to you for your perspectives first.
Thank you, Heather. Bonjour, Kanawea, Jesse McCormick, and Dishnakaz, Deshkan Ziving Nonjaba. My name is Jesse McCormick. I'm from Chippewas of the Thames First Nation. I serve as the Senior Vice President for Research, Innovation, and Legal Affairs for the First Nations Major Projects Coalition. We provide services to a membership of approximately 145, 150 First Nation members across Canada, with the objective of ensuring that they're in a position to make free-fired and informed decisions about projects taking place or proposed within their territories. So helping to fill the capacity gap with a specific focus on equity participation and the opportunities for First Nations to actually become owners of some of the major infrastructure projects and major projects being proposed in Canada. So we've got a portfolio of about $40 billion of project CapEx that we're looking to help First Nations become involved in, and working hard to advance issues such as access to capital. And we also spend a lot of time focusing on regulatory matters and the opportunities for First Nations to participate in project assessments and effectively advance their interests and have their concerns and views addressed effectively within those processes. Now, one thing Heather didn't mention in my introduction was I was also the Director of Policy to Catherine McKenna, the Honourable Catherine McKenna, the Minister of Environment and Climate Change, back in 2016. I came in January when she was brought on to help do a few things. Pretty busy portfolio for environment. I started as her Director of Regulatory Affairs and Indigenous Relations and was eventually promoted up to her Director of Policy. I wanted to do a quick retrospective on where we started, and that was Catherine's mandate letter, and that was to restore robust oversight and thorough environmental assessment of areas under federal jurisdiction while working with provinces and territories to avoid duplication, wanting to ensure that decisions were based on science, facts, and evidence, providing opportunities for Canadians to express their views and opportunities for experts to meaningfully participate, and also requiring projects to choose the best possible technologies to mitigate project effects. So that was paired up with letters for the Minister of Transport, the Minister of Fisheries and Oceans, and the Minister of Natural Resources Canada. So it was a large and significant cross-government endeavor to update and improve the various regulatory processes for major projects. It went through an expert panel with a representative from the mining industry, environmental assessment professional, First Nations lawyer, as well as forget the other person, and then ultimately a discussion paper by the Government of Canada in response to the expert panel's report. All of that culminating in Bill C-69, which was introduced in 2018 and received royal assent in June 2019 after, I think, having 186 different amendments proposed. The First Nations Major Projects Coalition, where I now work, was active in advancing the views of its members in the dialogues around C-69 and was very proud to have helped shape the legislation by contributing their expertise and knowledge in this area. And some of the key changes, and I would add that the Impact Assessment Act was a real step forward for First Nations from the Canadian Environmental Assessment Act of 2012, but mandatory consideration of impacts of a project on Indigenous rights, mandatory consideration and protection of Indigenous knowledge, recognition of Indigenous governing bodies as jurisdictions with whom Government of Canada could collaborate in executing and administering impact assessments, prohibition on designated projects proceeding without approval under the Impact Assessment Act. So that was something that was also present in CIA 2012. And then mandatory establishment of Indigenous Advisory Committees. So there are various components of this piece of legislation which were very important and very beneficial for Indigenous peoples. One that we are particularly fond of is what's being referred to in shorthand as the Indigenous Co-Administration Agreement Regulations. Section 114 gives the Minister of Environment and Climate Change the power to enter into agreements with Indigenous governing bodies as jurisdictions to authorize those Indigenous governing bodies to exercise powers or perform duties or functions in relation to the Act. So actually executing parts of the assessment or the complete assessment is part of the work under the Impact Assessment Act. So there's some real gems and opportunities for First Nations. On the question of how much work will be necessary to bring this piece of legislation into alignment, I think I may differ to some degree with Martin and Maureen. I see it more as trimming the hedges in some respects. I think the definition of federal effects will certainly need to change. I think there's likely to be some adjustments in relation to the ultimate test. The court expressed a preference against the public interest test that's established under the Impact Assessment Act. But it also said that the designation process, as well as the impact assessment itself, were both constitutionally valid, but the areas of decision-making for screening and the ultimate decision-making were constitutionally vulnerable. So the fact that the decision or the opinion determined that the act was unconstitutional, with the exception of section 81 to 91, isn't an indication that all of the content in the act would ultimately be found unconstitutional. It is the nature of the pith and substance analysis that you look at the act as a whole and determine whether its pith and substance, its dominant force is focused on matter of federal jurisdiction. In this case, they said no, but that doesn't deprive the Government of Canada from maintaining much of the content in the Impact Assessment Act. Thanks, Heather.
Thank you, Jesse. Lots of food for thought there. I'm sure Martin and Maureen have some ideas. You said there were 186 amendments proposed. I'm wondering how many were accepted, but we'll get to that maybe later. But first, I want to give Martin a chance, and he's also was at the Supreme Court of Canada. I saw everyone's posts on social media during the hearings in their excellent robes. And so, Martin, you've been very involved in this case and very experienced in it. Very curious to hear your perspective, especially what we've heard from the others.
Sure. And I think we'll deliver, I think, Heather, on your goal here to provide some, let's say, differing perspectives. And so I'll say at the outset that, yeah, I fall in the camp that says that decision, while it's important, and it certainly sends a strong signal that the federal government has to tighten the regime and focus it on adverse effects in areas of federal jurisdiction. I don't think it's a game changer on its own, anyways. And when, of course, we know that there's a political process happening currently at the federal level with a committee struck to sort of that was already going to look at streamlining, and now it's taking this recent decision and it's going to go from there and make some changes, and we'll see how far they push. I suggest that if they push hard, it won't simply be or strictly be on the basis of the Supreme Court's decision. I think there are some other things going on. In terms of the decision, I'll say, I don't have a problem putting my cards on the table that I was disappointed with the decision, but not simply or even primarily with the substantive result, which I think I can live with, but with some things that I'll get into in a second. I think in terms of the result, I was relieved that the Supreme Court reaffirmed the shared and overlapping nature of jurisdiction over the environment. So certainly each government has its own lanes, but we have to recognize that oftentimes those lanes are going to overlap, right? The so-called provincial projects or interprovincial projects are not immune from valid federal environmental legislation. The court made that very clear. And that the federal government has the jurisdiction to conduct impact assessment, that it can rely on a presumptive project list. And I know we're quoting, so I'll provide my own pinpoints here at paragraphs 142 and 143. And that the assessment of a project can be comprehensive, right? So the assessment is not limited to areas of federal jurisdiction. The assessment can be comprehensive. It's at the decision-making stage where we have to sort of refocus and think about and consider those adverse federal effects. And that's at paragraphs 157 to 161. So then why was I disappointed? I think I was disappointed really in a sense because when you read the decision, the case that keeps coming up over and over again really is Friends of the Old Man River. And that's a good decision, and we all learn it in law school. It's 3 decades old now. But you'd think that in the intervening 30 years that we might sort of move past and build in the jurisprudence some of the things that we've learned since that time, right? So, and we don't see any of that. We don't really see any kind of engagement with some of the sort of issues that are certainly were there in the pleadings and in the literature. And so, relatedly, I was disappointed by what I think was a fairly curt and incomplete analysis actually on some of the issues, right? So environmental law cases don't come before the Supreme Court that often. And so it's not clear to me why the decision was released a relatively short period of time. We're talking about 7 months when other decisions will often take at least a year. So I'm not sure why the court felt like it had to come out with this decision and leave so many things unanswered. And so it's a couple examples, I guess, so the court clearly embraces this distinction between jurisdiction over an activity and jurisdiction over a resource, and suggesting that somehow jurisdiction over an activity is more comprehensive than jurisdiction over a resource. But for instance, Parliament's jurisdiction over Indigenous peoples and lands reserved for Indigenous peoples is not jurisdiction over a resource or an activity, right? And so then, and speaking of that jurisdiction over Indigenous peoples, and I was heartened to hear Jesse's comments, the court gave virtually no guidance here about the breadth of this important jurisdiction, except to say that, well, we can't trigger a project on the base of any trivial change to Indigenous peoples and their interests. And so that's not really saying very much in the context of a major project resource regime, right, where we know that there are going to be material changes for the most part, right? So that's where I kind of fall. I think the decision's workable. I think that the federal government, again, I fall in that camp that says, if you tighten the screening decision, it's really the screening decision and the final decision around the project where there needs to be that focusing and tethering, more tightly to those adverse federal effects. And then, of course, the definition of federal effects itself. I read the court as simply saying that it can't be any change. But for instance, if you change that to adverse effect, I think in regards to Indigenous peoples, fish and fish habitat, migratory birds, species at risk, then I think you've met the hurdle that the court has put forward there. And of course, it's worth pointing out, I think, that like under the Fisheries Act, for instance, the prohibition against harmful alteration, disruption, or destruction is a very broad prohibition. So I don't think I don't think it would be very difficult to sort of just like raise the bar just a little bit there in terms of the effects on areas of federal jurisdiction in order to meet the court's sort of like opinion here. And so we'll see how that plays out. Like I said, I think there are other things going on at the same time at the federal level. So we'll have to see where Parliament lands.
Great. Well, thanks all of you for doing excellent table setting here for our discussion. So now we'll get into the questions, and it follows very closely to what Warren was just discussing. I'm not a lawyer. I'm a political scientist. So I'm really interested in the policy impacts of this decision. And so as we've all mentioned here, the judgment isn't totally clear. There is some vagueness. They did leave some questions unanswered. And as Maureen has said, Minister Guilbeault has said it needs some tweaking. We've also heard it needs some tightening, or as Martin has said, it needs some tethering. And then on the other side, the provinces are saying, basically, this is our carte blanche. And I think the Ontario Attorney General is saying that we need to put this to rest once for all. This was a reference. We're going to, try to get rid of this IA totally. And of course, Alberta, Saskatchewan would feel the same. And so my question to all of you is, there is a good, the government is doing its tweaking, whatever it's doing. There are some bigger contexts, as Martin said, of what they had already committed in budget 2023 to do some improvements. They didn't call it reform, they called it improvements to IAA. And so what happens if they do these improvements or these amendments and they come back and it's moderately revised in a way that industry and the provinces still don't find acceptable or don't feel in keeping with the decision? What does the next year or 2 or 3 years look like with this decision? I don't know who wants to start. Maureen, you're on.
Can I start? Yeah, mostly because I also wanted to tag onto something that Martin had to say, because I think it's a theme that sort of punctuates the two perspectives that are being, maybe there's 4 perspectives, but if we were to divide the perspectives on this call into 2, but Martin talked about, why the Supreme Court of Canada didn't do a deeper dive into some of the legal issues. And I think the people that I represent will talk about sort of the practical impact of this legislation and how critical it is to their businesses and these enormous projects in which companies have invested billions of dollars. And what we saw, not just in the judgment from the Supreme Court of Canada, but in the relative speed with which they responded, was some respect for that. Because uncertainty when it comes to big projects is the death of a big project. And like it or not, Canada is a huge country geographically, but small population-wise, and we are a resource-based economy. And so that is, I think, that another of the tugs that we see between the two perspectives. And then when we talk about what's necessary now in terms of next steps, obviously Parliament has to amend the Act. I was really disappointed right after the decision was released when the minister came out and said, notwithstanding the Supreme Court of Canada opinion, the Impact Assessment Agency of Canada would continue to consider projects currently under assessment. And he'd asked the agency to review each project, provide an opinion, and the only reason the agency can do that is because the Supreme Court of Canada opinion is an opinion, right? It's advisory. And so we still seem to be in this place where it's not clear what the federal government's going to do. It seems unacceptable to me that new projects may not fall under the Act, but some of the old ones may still be subject to the Act. And again, back to that theme of our economy and business and attracting foreign investment. And I think it was Catherine McKenna who said back in the day about the Trans Mountain Pipeline, if we're going to spend money on climate change, if we're going to be world leaders, we need to make some money as well. And so that, for me, that tug is a really important one. So what's next? I know the amendments are coming. I don't know what they're going to look like. One option is for the federal government to completely rethink the federal environmental assessment process and maybe return to a permit-based trigger, which would limit the environmental assessment to the permitting aspects of projects covered by the existing legislation, like the Fisheries Act. That's always my example. And that was, the others on the call may say that sounds a lot like SIA 2012, and that wasn't good enough. Another option, and this is the question that you asked, Heather, is if the federal government makes only minor amendments to the Impact Assessment Act, what happens? There's another constitutional challenge. That's what happens. And this is what the Supreme Court of Canada wrapped everyone's knuckles about. Like, get on with it. Stop coming to us with your bun fights. And I worry a little bit that there is conflation between politics and policy here. Is this really, if they come back with minor superficial amendments, is that proper policy, or is that playing to the politics of an issue, when an election is maybe a year or two in our future? So there you go, Jess, that's for you.
I saw Jesse smile when you referenced Catherine McKenna's qualified support for TMX. Who else wants to jump in here? I see both Martins have their microphones off. Maybe I'll go to Martin Olshinsky and then Martin Ignatiuk so that we switch it up a little bit.
Yeah, so I think it's pretty clear that if there isn't like a virtual sort of abdication from the field with respect to sort of what we might refer to as primarily provincial projects, like it's pretty clear. I don't think that neither Danielle Smith or Scott Moe are going to be pleased. And so actually my own view, and I can keep this like pretty short, I think that once the amendments are settled, once they're introduced, and of course there's going to be some politicking going on, but my own view is that as soon as the amendments are settled and in committee or once they're passed, I would refer them directly to the Supreme Court. Like let's not wait 4 years for it to go through a court of appeal. The federal government should just, we've done it. There's precedent with the securities legislation. We did this. Like the Supreme Court gave its sort of like marching orders. The federal government, I think it's worth pointing out, they said right away they're going to take it very seriously and that they're going to try to respond. They have their perspective on what is required. But I think then a good showing of faith is to once those amendments are made, is to refer them back to the Supreme Court and say, have we met the bar here in this context? And I think that that is probably the fastest way to bring certainty to whatever it is that they cook up in the long run.
Thanks. Martin?
So, yeah, thanks, Heather. I think there is some certainty in this decision in the sense that one of the things the court did do is it drove a truck through the idea that the federal government can come up with a list of projects and impose legally binding prohibitions on them just because it's a large-scale project. That's done. And if the federal government, and I'm concerned like Maureen that I haven't heard any of the federal ministers acknowledge that to any extent when they talk about the future of federal environmental assessment. So, the fact people are wondering whether the federal government will respect the decision when it comes up with a new regime, if it does, it is concerning to me to start with. But let's be clear. This decision had immediate impacts for all of those projects that were designated that don't require a federal permit. And, the courts made it clear, just because something impacts Indigenous people doesn't mean the federal government has jurisdiction. And that should be obvious to everyone, because everything every order of government does impacts Aboriginal people, Indigenous people to some extent, right? So that would be the Trojan horse that the courts warned against previously. So, look, I think the federal government should take a step back and think about not only what complies with the decision, but what's good policy. It is crazy that right now we spend hundreds of thousands of dollars in project-specific hearings debating whether federal air emission standards should apply or provincial air emission standards. They both shouldn't be regulating the same thing. It doesn't make sense. And we don't have two levels of government in this country. We have two orders of government with different responsibilities. And I think the federal government has to respect that. So look, I think the decision is going to have big implication, because if the federal government tries to ignore it and tries to say we're going to prevent, a major mining project from proceeding before we even look at whether they need a Fisheries Act permit, I think people like me and Maureen are going to tell our clients, ignore that. We'll go to court, get a declaration, or proceed. They can never enforce that. Like the Supreme Court's made that clear in this decision. So I think the federal government has to respect that, take a step back and say, how do we get back to regulating the areas we should regulate? And if I do have a project that needs a Fisheries Act permit, and then I look at that process and don't like it, and I can redesign my project so I don't need that Fisheries Act permit, I'm good to go from a federal perspective. That's how it used to be. And that's good policy, because it encourages proponents to have less impacts on areas of federal jurisdiction, which should be the intent of the law in the first place. So I think that the federal government should really have an honest discussion. I'm really concerned with all the challenges this federal government's currently facing, that they don't have the wherewithal to have an honest discussion about that right now, given all the political pressures. But I think it would be helpful to have that discussion.
So Martin, I'm gathering that regardless of what happens, the lawyers will be winners in this. So congratulations to all you guys. But Jesse, I'll give you a chance to weigh in on this before we move to the next question.
Sure. Just some reflections. So during the development of C69, the government of Canada, I think under Environment and Climate Change, established something called the Multi-Interest Advisory Committee. They pulled in environmental NGOs, Indigenous representatives from Inuit, Métis, and First Nation organizations, as well as industry representatives. And they sat them down for multiple sessions and tried to get to a spot where they'd work out and come to points of agreement, recognizing they wouldn't necessarily agree on everything. There would be points of overlap and understanding, and those were good points of departure. And in advancing this work, I remember a conversation I had with Marlo Reynolds, who was chief of staff to Catherine at the time. And Marlo said, what does a win look like on this file from a political perspective? And it was, everyone's a little bit angry with us, but no one's too angry with us, because the interests that are at stake don't align in all respects. So what the environmental community may want may differ from what the industry community may want, and trying to find that sweet spot in the middle, I think, is an important part of it. And it's important to start from the perspective that those are all valid views on how we should conduct impact assessment. And we need to ensure that we're conducting them on the basis of sustainability, in addition to economic development and competitiveness. On the question of 9124, Section 9124 of the Constitution Act for Indians and the lands reserved for Indians, my favorite quote from the Court of Appeal at paragraph 316 was, Section 9124 provides no constitutional basis for parliaments imprisoning Indigenous peoples in their own Aboriginal and treaty rights. And I thought it was a confounding misunderstanding of how Indigenous folks will see their relationship with the decisions that need to be made in relation to projects impacting their territories. And I think there's a fundamental reframing that needed to take place. And some of that was present in the Impact Assessment Act. And in terms of making the changes necessary, there will certainly need to be changes, particularly to funnel decisions more closely to federal areas of power. But there's still a valid federal impact assessment power, or ability of federal government to conduct impact assessments. And it's about finding that sweet spot that respects that power, while at the same time doesn't overstep.
I bet Maureen loved that quote, and I bet she has it emblazoned on a pillow somewhere, because it was probably at root some of her argument for her client, but we'll get to that. Time is flying, as I knew it would. The question a lot of people have in mind, would love all of your perspectives on, is its effect on other controversial regulations now in the process. So obviously, it looks like the clean electricity regulations will be challenged. The oil and gas emissions cap sounds like it'll be challenged by Alberta and Saskatchewan. How do you guys think that this Impact Assessment Act decision makes that more or less likely to succeed? And with the time running out, I'm going to ask you to keep it to about 2 minutes each in your responses. Who wants to start? Martin.
So Heather, I'll start. Let me just quick, because I'm not going to talk about the clean air, the clean electricity regulations, or the federal emissions cap. I think others will. But and I think, like I said when I started, I think the court offers a little bit on that, not much, but it does offer quite a bit on two existing pieces of legislation. First of all, the Fisheries Act. There's several paragraphs in the decision that raise serious questions with how Environment Canada has been interpreting parts of the Fisheries Act the last few years. They have been threatening a number of industry proponents with the view that if a single molecule escapes a tailings pond and enters a river with fish, that contravenes the Fisheries Act. It's totally detached from any issue of harm to fish. I think there's paragraphs in the Supreme Court decision that's raised serious issues about that kind of interpretation of that act. It was never meant to be applied that way, and it makes no practical sense either. So there's definitely a warning there. And the Migratory Birds Convention Act, which has become one of our signature federal pieces of environmental legislation, despite the fact it's based on a convention that was supposed to protect the rights of hunters of birds on both sides of the border. They raised some questions about whether that act now goes significantly beyond what was agreed to in that treaty, and raised questions about it. So I think for proponents who are having issues with Environment Canada on those two pieces of legislation, you have to revisit that case to see how it might impact your situation. And then I'll leave it to others to talk about the more newsworthy debates that are happening today on federal legislation.
I see Maureen has her mic off. Martin,
Yeah.
don't take us down the fisheries rabbit hole now, although I'm sure I interviewed with that. But Maureen, I'll pass it on to you.
There's nothing more that Martin likes than a good fisheries conversation. Martin O, that is. So contrary to what many believe, the federal government does not have unconstrained power over the regulation of GHG emissions and climate change. And I think we all acknowledge there's a shared responsibility for the environment, provincially and federally. But the Supreme Court, in its reference, expressed real concern that effects within federal jurisdiction under the IAA might allow the federal government to deny projects on their solely on the basis of greenhouse gas emissions. And the majority held that goes beyond the national concern. That same national concern argument that the Greenhouse Gas Pollution Pricing Act referenced a few years ago. So the court's reasoning on that point, in my view, in the decision, was a big loss for the current federal government, which has prioritized greenhouse gas reductions and repeatedly relied on greenhouse gas impacts as a basis to assert federal jurisdiction to assess projects. So the Supreme Court also was really critical of federal attempts to regulate province based on policy priorities, things like emission caps, the regulation of provincial electricity, net zero requirements. And this is precisely what the federal government is doing, picking and choosing resource projects based on federal policies and priorities. So it remains to be seen how the federal government will defend the emissions cap or the clean electricity regulations. But I think the reference decision doesn't strengthen the federal government's arguments on the clean energy regulations or the oil and gas emissions cap. I think there's a lot of fodder. People like me are, going, can't wait for the next constitutional challenge because it's coming. And I see the decision as being very strongly, it's a real hurdle for the federal governments if they're going to try to make this argument again.
Jesse or Martin, how do you guys want to respond?
I can jump in. So it's not directly relevant because the feds have made it pretty clear that insofar as the electricity regulations and the cap, they're relying on their criminal law power. I do think that and that was essentially, the court mentioned the criminal law power, kind of throw a shout out to the Hydro-Quebec decision from the 90s, which upheld the CEPA regime, the Canadian Environmental Protection Act, as a valid exercise of the criminal law power. And of course, these regulations, the electricity regulation and the cap, will be regulations, it looks like, under that legislation. But there's a vibe, I think, absolutely to the case, which is just, again, the Supreme Court sort of reminding, I think, the Fed that there are rules, right? And so, stepping back a bit to what I said at the beginning, I mean, I think it is really important that the court actually made it very clear that in this space, we have the double aspects doctrine, right? So any given fact situation, any given project can be regulated validly by the provincial government through its various heads of power and the lawmaking powers provided thereunder. But that also the same fact situation may have a federal aspect, and that the federal government may legislate and regulate so long as it follows the rules applicable to each of those different heads of powers. And so I think in the context of the clean electricity regulations and the oil and gas emissions cap, of course, the classic requirements for the criminal law power are around a prohibition backed by a penalty for a valid criminal law purpose. Those are kind of the trifecta. And without getting into the weeds about it, I think what's interesting is that, of course, industry has been clamoring and requesting and seeking a lot of flexibility. If these, of course, they would prefer not to deal with these regulations, but if they're going to have to deal with them, they want them to be as flexible as possible, as economically efficient as possible. But then they're going to weaponize that flexibility to say that Parliament has exceeded, that the federal government has exceeded its criminal law jurisdiction on the basis of that flexibility. And so that's something that the federal government has to be, I think, aware of, is that that's a risk, and how they want to play that risk. There are cases. There's a Syncrude litigation from a few years back, which upheld the renewable fuel regulations under SEPA. There was a market-based compliance mechanism in that regulation. So there is jurisprudence that supports a fairly, let's say, broad approach to the criminal law power. But for sure, there will be litigation, and all of us will be talking about it for years to come. On the Fisheries Act, Martin, I can't help myself. I have to say, so there is long-standing precedent that it's an end of pipe test as opposed to like in the environment sort of test. And that's okay. Northwest Falling sort of, and we have cases from BC in particular that talk about, a bunker C oil, one drop. Now, there's always going to be a de minimis, I think, aspect to the fishery, to all these environmental laws. You don't want to be catching trivial harms. But I think so long as the government has a legitimate and valid basis to be concerned about an adverse effect, the potential for an adverse effect, then it's probably on safe ground. But we can talk more about that some other time.
Jesse, I'm not going to let you answer, although you can, because I want to get to Indigenous rights, and we're closely running out of time. So, yeah, and you mentioned this in your opening remarks that all the gems, as you said, that the Impact Assessment Act brought to Indigenous rights and Indigenous consultation. And part of what you said is there was mandatory consideration of Indigenous rights. And I just know that Martin, I would say it's not the IAA that imposes mandatory consideration of Indigenous rights. That's in the Constitution. So Jesse, I want to start with you, but hopefully get everyone else's input. Does the decision compromise Indigenous rights and Indigenous protections? And if it does, how can it be reformed without impacting those Indigenous rights? Jesse, we'll start with you.
Thanks, Heather. Well, a few thoughts. One is that it does compromise in the sense that the opinion places at risk the protections that are presently available in the Impact Assessment Act. But the ball is in the Government of Canada's court in terms of developing its amendments and what it chooses to bring back. And assuming it chooses to bring back what it has generally within the Impact Assessment Act, then those can be maintained and held on to. And I think that would be a positive thing. And when asked, I typically advocate for the idea that they should be taking the position of strong or stronger in relation to the Indigenous provisions in the Impact Assessment Act. And on the question of constitutional versus statutory protections, I think there's an element of having a statutory protection embedded within legislation itself, because that helps to streamline departmental considerations. It helps to align the work of consideration with the broader Impact Assessment Act work. There's an excellent blog, the Ab Law blog by Robert Hamilton, I believe, is one of Martin Olshinsky's colleagues, but he looked closely at the decision in relation to some of the opportunities in the Impact Assessment Act, and basically found it wanting in terms of its assessment of where 9124, the constitutional jurisdiction for the federal government over Indians and lands reserved for the Indians, and its relationship to Section 35, which is the protection of the existing Aboriginal and treaty rights of Indigenous peoples, and lack of direction on the declaration, which I don't believe is the Declaration on the Rights of Indigenous Peoples, I don't believe is referenced in the decision at all, and also the more broadly the scope of Section 9124. The court basically goes so far as to, and fairly so, the wording of federal effects uses language like any or all, and it captures a broad scope of potential impacts. I bumped my Anishinaabe toe on the pylon outside the project, and suddenly you're starting to get into the scope of the act, and that is a step too far. So, but it hasn't provided much guidance in terms of when rolling that back, how far you have to roll it back. But there is one little gem in the decision that stood out to me, and that was at paragraph, bear with me one second, 151, the IAA requires the agency to take into account an open-ended list of factors, all of seemingly equal importance. Only sections 16.2b and c relate to adverse effects within federal jurisdiction. And section 16.2b refers specifically to, or 16.2c refers specifically to adverse impacts the designated project may have on the rights of Indigenous peoples of Canada, recognized and affirmed by Section 35 of the Constitution Act. So that's something that may be just a little gem in the rough, but this idea that you had some level of alignment between Section 9124 and Section 35 is something that I'm certain see more from the Supreme Court on. But at the end of the day, notionally, the opinion puts the protections in relation to Indigenous peoples at risk. I think the federal government will likely seek to uphold all of those parameters. It will have to tailor to a greater degree the federal effects language to narrow it somewhat, perhaps with some form of threshold, maybe a return to a significant adverse effects assessment. And there's also the possibility of stepping forward and doing more. Are there opportunities to enhance the protections or enhance the participation of Indigenous peoples in a way that would strengthen both the competitiveness of projects moving forward and the protection of Indigenous interests? And I think there are opportunities there. So I would encourage those who are listening to us today to think creatively and engage effectively with Indigenous partners to identify opportunities to align regulatory efficiencies with greater Indigenous participation and involvement in all aspects of impact assessment, including decision making.
Thanks, Jesse. We're running out of time, so about one more minute, Martin or Maureen, and Martin Olshinsky, if you want to add too. But I'll start with Ignaziuk, because I know that it's not for you. It's not the IAA that is protecting Indigenous rights. So how do you see this affecting those rights and protections?
Yeah, so I mean, I think the first point, Heather, is it should be recognized there's a number of Indigenous groups opposed to what the IAA does because it doesn't take into account their economic interests and their desire to achieve reconciliation by improving their economic situations. And Environment Canada's refused to consider that as part of its decision making. So there are a number of Indigenous groups who view that as a significant deficiency. I think, though, Indigenous in consultation is obviously very important. It's ingrained in everything we do now when it comes to projects, both at the provincial and federal levels. But the reality is, if the Impact Assessment Act no longer exists, which is basically the case today, and if they don't introduce anything new, it doesn't change the federal government's obligations to Indigenous communities one iota. If they're going to issue a Fisheries Act permit or Species at Risk permit, they still have all of the constitutional obligations to consult on those decisions if they might impact Indigenous communities, just like they did under the IAA. So those departments, even without Environment Canada, or in the case of fisheries, could implement whatever regime they think necessary to do that. And the provinces are under the same obligation with respect to the parts of projects under their responsibility. So a very important issue, but I don't think it's central to this, which is really about regulating projects.
Thanks, Martin. Anyone else want to have a quick repost to that in about a minute? Maureen or Martin Olshinsky? All right. Well, then we're coming to the final question here. And I'm glad we got to this question because I'm very interested from this fine panel about how they would like to see it proceed. They all think about the Impact Assessment Act a lot, about regulation a lot. And so I wanted to ask you guys as we close off about 2 minutes each, to your mind, how should the IAA be amended? What would be the best case scenario for you? And maybe Martin Olshinsky, I'll start with you.
All right. So I wasn't expecting that. So I want to say before I go, because I know I sound sometimes like perhaps that I'm not concerned about economic matters. I guess I wanted to point out that I'm sitting in the province right now that currently imposed a 6-month moratorium on renewable energy project development, right? So I find it a little bit tricky. I think we have to be, try not to be, we want to sort of have equal treatment or think about these things from that perspective as well. There are all kinds of projects, and it looks like governments of both stripes, of both sort of political leanings, like to get involved in picking favorites and blocking others. So I think that's really important. In terms of changes going forward, I think my own view is we've had 4 different regimes in this country in 4 decades. I don't think we need a 5th. I can't help but be a little bit puzzled, to my understanding of the history, and these are kind of just like maybe it's gossip or rumors, but we went from CN92 to CN 2012 in large part on the advice of some of the lawyers downtown here in Calgary. So I find it pretty interesting that we would go back to CN92, for instance. I think this system can work. I think that there are some problems with it, and people have probably, the regulators, federal departments have identified some of those problems even before this decision came out, which is why we were talking about improving and putting money towards the system to sort of make sure that, the other big, Jesse's other big mantra, I think back in the day, was getting good projects built, right? And so I think we can do that. I do think it means acknowledging that when you have big projects, complex projects that do engage both levels of jurisdiction, both levels of government, orders of government, that there's going to need to be a coordinating process, and that can be a good thing, and that it can streamline and bring efficiencies instead of having each department off doing their own thing. And because we saw that didn't work great under 92 either, under CN 92. So I think targeted amendments and moving forward and making the system work. We can talk about ways to make it more efficient. We've spent a lot of time. I'm on a council where we spent a lot of time thinking about those things. I think it can be done, but it does require good faith, and it does require everybody to come and be prepared to sort of that nobody will be happy, to Jesse's point. Not everybody will be happy. Most people won't be happy, but can they live with it? And I think that's the lodestar here.
Thanks so much, Martin. Maureen, I'll move to you.
Go ahead, Martin, your mic's off.
Sorry, Maureen, I think she's...
No, that's
I'm
okay.
just saying, go ahead, Martin. I saw your mic off.
He's deferring to you. Go ahead, Martin Ignaziuk.
Doesn't happen very often. I'm
Oh,
deferring.
sorry. Yeah, no. Sorry, Maureen. Yeah, look, Heather, so I think, we've talked about the federal government has to acknowledge the impact of this decision. But I think the biggest thing is this. I think everyone has to recognize that environmental assessments of individual industrial and resource projects is never going to be the panacea for all the world's problems. We're not going to solve gender issues. We're not going to solve all of the incredible challenges faced by Indigenous communities by trying to deal with those in the context of the review of a specific industrial or natural resource project. So we have to get the focus of these assessments right. It's about the fact that we need these projects. We need investment from around the world to make these projects happen because they're expensive, they're complicated, but they're strategically important for geopolitical purposes and to maintain our standard of living. And putting all these requirements to solve all of the world's problems on every project proponent, it's not working. It's what's chased investment away from this country. And that started before the IAA, because SIA 2012, unfortunately, introduced a lot of these concepts that have been carried through. So I think we have to have a recognition that the main focus of any legislation should be how do we get these projects carried out in a timely way in the most environmentally responsible way. And the way to do that is to have the assessment focused on the environmental effects within the jurisdiction of each government. So the government of Canada should beef up its ability to regulate fisheries. It should look at the other areas it's responsible for, and the province should be looking at the rest because that's where the rest lies. And I think if we all respect that as a starting point, we'll have a very good environmental assessment regime.
Thank you, Martin. Maureen, you got about 1 minute for your thoughts.
I can't say it better than Martin did. I will just say that, we have to remind ourselves that, as Martin says, that the environmental assessment process can't be a panacea. If we try to make it a panacea, companies like Kinder Morgan will leave Canada, and Canada will have to buy projects and run them themselves. I mean, that was the reality of what happened there. Things got too complicated. Kinder Morgan couldn't explain to its shareholders why they continued to invest in Canada with all the hurdles that were being placed in front of them. So if we want to nationalize every large project, okay, let's have a different regulatory approach. But if we want to continue to attract investment, if we want to be an economic power that can invest in a record where we have the best Indigenous rights and human rights, and we have a society that has the benefits that come along with that kind of an economy, then we have to find the right balance, and we have not found that.
Thank you. And Jesse, you will have the last word.
Thank you, Heather. I'll keep it brief. A few tailored amendments that I think merit consideration. I think certainly we'll have to work on the definition of effects within federal jurisdiction in Section 2. And that'll require some tailoring in order to ensure there's not capturing de minimis impacts, so some level of threshold or something like that. I'm going to have to channel Section 16 to capture federal effects in a more direct way. I think there's probably a case for a return to a significant adverse effects determination with a justification decision following. I would add that I think the Impact Assessment Agency of Canada should offer its views on whether there's significant adverse effects, rather than the current structure where they don't offer an opinion on the project. They merely provide the report. That was helpful under CA 2012. Finding a way to ensure that you have greater tailoring under tailored impact statement guidelines. Although not an amendment, greater capacity for Indigenous peoples to participate effectively and participate at the speed of the assessment. And I think there's room for considering some form of Indigenous accelerator mechanism where you have alignment between a proponent and an Indigenous partner, and the project is squarely within their territory. Perhaps some of the content of the Act can be pushed to the side, where the Indigenous community has been satisfied itself that the project's impacts will be effectively mitigated. And I think last thought is simply the legislation includes many tools for collaboration. And presently, not a lot of provinces have picked up that opportunity and run with it. So to the degree that we want to see greater certainty and greater confidence in the investment climate in Canada, there is a responsibility on the part of the provinces to also seek to work collaboratively with the Government of Canada. And unfortunately, in many aspects, we're not seeing that.
All right. Well, thank you all for your thoughts today. Thanks to the audience for listening. I'm not a judge, even though I was in front of these 4 lawyers today, but I do have an opinion. This webinar was excellent. Thanks to all of you for your thoughts. And, you can find us on this webinar if you want to share it with friends on YouTube. Thank you, everybody. And everyone have a great, happy holidays, and talk to you soon, hopefully. Take care.
Thanks, Heather. Thanks, everybody. Jesse, Martin.
Thanks, Heather.